My name is Rhonda Evans. I'm a senior lecturer in the Department of Government at the University of Texas at Austin, and I direct the Edward A. Clark Center for Australian and New Zealand Studies there. So I gave a paper that tapped into the theme of Catherine's book about government court tension, looking at the High Court of Australia. And so what I was interested in was one particular way in which that tension plays out, which is not the more familiar way of looking at specific court cases that pit the government against an asylum seeker claiming human rights, but rather tension that emanates from the court being overburdened by the volume of cases. And how does the court cope with that when the sheer number of migration cases reaching the court threatens to jeopardize what it sees as its role, which is not as a trial court, is more of an appellate court, making important constitutional decisions. And so I analyzed that in the context of a specific case that actually raised both dimensions of that tension. It was a case of an asylum seeker versus the government, and it was also a case where the decision would have implications for the court's workload. The High Court of Australia saw its caseload of migration decisions grow pretty dramatically since 2000. And that's a fairly new phenomenon. Before that, it had only decided a handful of cases per year. At about that same period of time, it also saw a lot of other cases the court did not decide, but were seeking a hearing before the court, and the court was able to filter those out. So the court has demands in two ways. The more visible is the actual cases it decides concerning migration, but sort of a subterranean set of cases are the people who apply to the court to have their case heard, and the court's able to say no. Deciding those applications also consume a lot of the court's time. And what's at stake is that asylum seekers want to have a decision reversed where they're denied a visa, often a protection visa when we're talking about asylum seekers. And aside from what's at stake for the individual in a particular case, there are often significant policy implications. So for instance, when someone is claiming that they should be freed from immigration detention, they not only want their freedom, but if the court is to rule in their favor, the court may invalidate an important policy. And so not all, but many of the cases where you have an individual simply seeking redress for themselves, the case actually has far wider import for the government's policy. And of course, the government wants to maintain its policies. It doesn't want the court to throw them out. And the court is unelected. Justices are appointed by the government. They're not elected. And so it raises issues about unelected officials depriving the people's representatives of the policies that they've enacted through parliamentary process.